I need like 3 minutes. Sorry. Am I on? Hey everybody, this is Amy Quackenboss. How are you guys doing? Sorry, I'm well, thank you. Sorry, I was tied up in another meeting. I'm going to be introducing you all today, so I'll do a quick introduction of the program, and then we'll introduce each of you. After I do the introductions, who should I hand the panel off to? Okay, great. How are you doing, Abigail?
Mode.
Good afternoon. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. I'm pleased to welcome you to the next webinar in our ABI-Live series. Today's webinar, which is hosted by ABI's Young and New Members Committee, is entitled ASARCO, the Implied Impact of Baker v. Botts in Professional Fee Litigation. Before I introduce you to the panel of speakers today, I'd like to address a couple of housekeeping matters. If you need CLE, please make sure you are recording the CLE codes that will appear on your screen throughout the program. Also, during the webinar, if you have any questions for the panelists, please type them in the GoToWebinar conversation box on the right of your screen. These questions will then be sent directly to our panelists and they'll answer them throughout the program. So I'm now pleased to introduce you to today's panel. Our first speaker is Kyle Hirsch of Bryan Cave in Phoenix, Arizona. Kyle litigates business disputes with a strong focus representing financial institutions and non-traditional lenders in connection with loans secured by real estate and operating business assets. Kyle's practice spans state, federal, and bankruptcy courts in Arizona, as well as California, Texas, and Nevada. He has litigated matters across numerous disciplines, including hotels, multifamily housing, commercial and residential development, retail, healthcare, energy, construction, manufacturing, and distribution. Kyle applies his Spanish language fluency to provide pro bono legal assistance to deserving members of the Phoenix community as well. Our next speaker is Shanti Katona. She's with Polsinelli in Wilmington. Shanti works with debtors and creditors in all capacities, including handling numerous adversary actions. Her litigation experience is dynamic and includes a variety of matters from fraudulent transfer and preferences litigation to prosecuting breaches of fiduciary duty. Shanti approaches each matter by evaluating the claims and formulating cost-effective litigation strategies specific to each matter and client. She also has experience representing financial institutions and other creditors in the enforcement and workout of commercial and real estate loans in both federal and state courts. Our last speaker is Abigail Willey. She's with the U.S. Bankruptcy Court in St. Louis, Missouri. Ms. Willey has served as the career law clerk to Judge Charles Renlin III, who is a U.S. bankruptcy judge in St. Louis. Prior to clerking for Judge Renlin, she served as the law clerk to Judge Raymond, I'm going to get this wrong, Grunder. Is that right, Abigail?
It's actually Grunder, but good guess.
I tried. Of the U.S. Court of Appeals for the 8th Circuit, and as the law clerk to George P. Katzen of the U.S. District Court for the Southern District of Texas. She also practiced corporate insolvency law for several years at Vincent & Elkins in Dallas, Texas. So welcome all of our panelists, and Abigail, I'm going to turn it over to you.
Thank you. Could we go ahead to the first slide, please? Okay, next slide after that, that's the title page. This is a little bit of disclaimer language. The materials are designed to provide general information regarding the subject matter covered. This general information is provided with the understanding that the authors are not engaged in rendering legal advice. In the event you require legal advice, you should seek the services of licensed legal counsel in the applicable jurisdiction. Please also note that I work for the federal judiciary, and nothing that I offer is an opinion of my judge or any judge or the federal judiciary. I'm simply speaking in my own capacity. Next slide, please. Thank you. Let's start with an overview of how to get employed and how to get paid as an estate professional. You're going to be looking at sections 327, 328, 329, and 330 of the Bankruptcy Code. A professional rendering services to the case trustee or debtor in possession, of course, can't be paid from estate assets unless both his employment and specifically his fees are approved by the court. The failure to be retained can result in the professional's application for payment for services being denied. In particular, my judge has, in fact, denied a professional's application for payment when he failed to properly be retained before providing services. Nunc pro tunc, in my experience, has been that is not a very good fallback position. In an argument once made before my judge, that was the relief requested. We meant to be retained, but we forgot to be retained, and then we provided services. So let's just nunc pro tunc it all back and fix it. Nunc pro tunc is relief that's usually afforded for the purpose of correcting a previous order. If there was no previous retention order, that's not a particularly strong position to take. So if you want to be paid, get retained first. Employment and payment is governed, as I pointed out, primarily by those 4 sections of the Bankruptcy Code. Advance to the next slide, please. Thank you. Let's start with Section 327. 327 provides in relevant part that the trustee, including a DIP, with the court's approval, may employ one or more attorneys, accountants, auctioneers, or other types of professionals that do not hold or represent an interest averse to the estate, or, and, importantly, that are disinterested persons to represent or assist the trustee. As such, Section 327 sets forth a conjunctive, 2-pronged standard for the employment of a professional person. You can't have an adverse interest, and you must be disinterested. Let's take a look at what those terms mean. Next slide. Could we advance to the next slide? Oh dear. Alrighty. An adverse interest is not defined by the Bankruptcy Code, but case law does give us some illumination. In general, it means to possess or assert any economic interest that would tend to lessen the value of the bankruptcy estate, or that would create either an actual or potential dispute in which the estate is a rival claimant, or to possess a predisposition under the circumstances that would render bias. Please advance. This means that an adverse interest can be economic, and it can also be non-economic. Although this isn't an exact parallel, it might be appropriate to think of 28 U.S.C. Section 455, which is the federal judicial disqualification statute, and that provides both economic as well as non-economic bases upon which a judge must recuse himself. Sort of a similar idea. Next slide, please. Now, a disinterested person is in fact defined by the Bankruptcy Code in Section 101.14. It's a person who does not have an interest materially adverse to the interest of the estate or any class of creditors or equity security holders by reason of any direct or indirect relationship to, connection with, or interest in the debtor, or for any other reason. So it's fairly broad language for determining a disinterested person. Next slide, please. So again, as such, between the adverse interest requirement and the disinterested standard, a professional cannot have an actual conflict with the estate or a materially adverse interest of a class of creditors or equity security holders. Next slide, please. Bankruptcy Rule 2014 is the pragmatic part. It dovetails with Section 327, and it requires that an order approving employment under 327 may be made only on application of the trustee or the committee, and it has things that the application must include. It has to include, as the list shows, specific facts showing the necessity for the employment, the name of the person to be employed, the reasons for the selection, the professional services to be rendered, any proposed arrangement for compensation, and, to the best of the applicant's knowledge, all of the person's connections with the debtor, creditors, other parties in interest, respective attorneys, the U.S. Trustee's Office, and so forth. In my experience, it is better to default to more than less. If you're not sure if you have to disclose it, you probably should. The obligation with the court is not simply to skate by on the minimal facts, but it's a standard of candidness and candor with the court. So your Rule 2014 application should reflect that goal of complete candidness. Next slide, please. In addition, the Rule 2014 application has to be accompanied by a verified statement of the person to be employed, setting forth the person's connections to the debtor, creditors, other parties in interest, and so forth. So it's not just enough that the applicant themselves makes the representations regarding connections, but the person who's actually seeking to be hired must as well. Next slide, please. Moving on. The next section is Section 328, and it provides that the trustee or the committee may, with court approval, employ or authorize the employment of a professional person under Section 327 on any reasonable terms and conditions of employment, including retainer, hourly basis, fixed, contingency, so forth. Next slide. In addition, Section 328 provides that the court may deny allowance of compensation for a 327 professional if at any time the person's employment, during the person's employment, the person is shown to have an adverse interest or is no longer disinterested. This points out something important. Be sure to continue on an ongoing basis checking your adverse interest in disinterestedness standard, and be sure to supplement if you have any facts that the court needs to be aware of. Ordinarily, Section 328 is used by professionals who provides services for a fee that isn't usually calculated by the common hours work multiplied by hours rate structure. This is not generally the provision under which most counsel representing debtors makes an application. Under Section 328, the agreed upon fee structure, it's more or less set, regardless of whether the provider gets a windfall or is essentially underpaid when it's all said and done. So there's both security in a Section 328 employment because it's almost pre-approved, but there's also a risk if you do better or if you do considerably worse than what you had been anticipating. Next slide, please. Moving on to Section 329. This provides additional specific guidance for attorneys retained to provide services to the estate. When an attorney represents a debtor in or in connection with a bankruptcy case, that is also before the bankruptcy case is commenced, and regardless of whether the attorney ever applies for court-authorized compensation, the attorney must file a statement of, 1, the compensation paid or agreed to be paid, if such payment was made after 1 year before the date of the filing of the petition for services rendered, to be rendered in contemplation of, or in connection with the case. So that casts a pretty wide net, everything looking back. And also the source of the compensation. If any of you are familiar with the recent case of Upright Law, you're aware of the dangers of failing to properly disclose who pays the debtor's fees. Upright is a virtual firm that had a third party paying some of the fees for its clients, and it got into a world of trouble. The bankruptcy court in Virginia didn't like that recently, when they didn't disclose who was paying the debtor paying for the debtor's filing fees and attorney's fees. Next slide, please. Actually, let me touch base on one additional point regarding 329 before we advance. 329 also provides that if the court determines that you have violated 329, or alternatively, if you have not earned the fees that you have been paid for, the court can cancel the retention contract. Alternatively, and in addition, it can order disgorgement of the fees. My judge here in the Eastern District of Missouri was involved in a 329 disgorgement action, and it can become pretty professionally embarrassing as well as hazardous to the practice. So be certain that you are in compliance with 329. I'm sorry, I can no longer. Thank you very much. Thank you. Section 330 is the usual way that an attorney is paid when they're hired under 327. Section 327, it affects the traditional lodestar analysis, which we're all familiar with, whereby the court calculates the appropriate hourly rate, and then that rate is multiplied by the hours worked, and then you're going to back out certain hours for duplicative efforts that were particularly unproductive, were excessive, or are otherwise unnecessary. That gets backed out. Next slide, please. Section 330 provides that the court may award a professional reasonable compensation for actual necessary services rendered. That language will become important in ASARCO, and reimbursement for actual necessary expenses. However, the court may award compensation that is less than the amount requested. In an unusual circumstance of exceptional performance and benefit to the estate, the professional can also seek, but isn't necessarily going to get, a fee enhancement. And there was a fee enhancement in ASARCO, but that fee enhancement actually was not the point of the appeal. It was a different issue. Next slide, please. This is the all relevant factors test for determining what is reasonable compensation. I'll go through the list quickly. Time spent for the services, rates charged for the services, whether the services were necessary to the administration of or beneficial at the time, whether the services were performed within a reasonable amount of time commensurate with the complexity, importance, and nature of the problem, issue, or task. With respect to professional person, whether the person is board certified or otherwise has some sort of demonstrated skill. Obviously, this is why partners at law firms are compensated at a higher rate than new associates. And whether the compensation is reasonable based on the customary compensation charged by comparably skilled practitioners in cases other than the case that's before the court. Please advance to the next slide. In addition, and consistent with the lodestar test, the court cannot order compensation for any services that were duplication, were not reasonably likely to benefit the estate, or were not necessary to estate administration. These will become issues in ASARCO. Please advance. Now let's turn to the case at hand that we're all interested in. ASARCO and compensation of 327 attorneys under 330 for fees and expenses related in defending a fee application. So as we all know, you have to file a fee application in order to get paid after you've been retained and provided services. Sometimes people don't like your fees. Sometimes people want to object to the amount of the fees or the nature of the fees. And for years, there was a circuit split as to whether or not the time invested in defending a fee application was compensable from the estate, and ASARCO resolved that split. In 2015, in the case of formerly Baker Botts versus ASARCO, the U.S. Supreme Court determined that fees incurred by an attorney defending an attorney's fee application were not compensable under Section 330. This was just a 330 case, although as we see, the authorities generally take the position now, although it's a question, that it applies equally to attorneys who are retained, attorneys who are paid under 328. Next slide, please. So let me give you a little bit of background. First, a long time ago, 20 years ago, I was a summer associate at Baker Botts, and I knew some of their bankruptcy people, and they are fantastic people. So I'm not the slightest bit surprised that they saw such success in ASARCO. The ASARCO is short for the American Smelting and Refining Company. It was this 100-plus-year-old producer of copper and other types of semi-valuable metals. By the mid-2000s, it was facing significant market problems, labor strikes, credit downgrades, had huge bond debt, had leasing obligations, and it was embroiled in asbestos litigation. So it retained the Texas-based international law firm of Baker Botts as its lead counsel, along with the firm of Jordan Hayden, and it ended up filing for bankruptcy in 2005. Next slide, please. So all of the details about ASARCO's representation by the firms, it's sort of beyond the scope, and time's not going to permit it here, but it should be noted that this really wasn't contested. There was extraordinary lawyering by ASARCO's counsel. They obtained a multi-billion-dollar fraudulent transfer judgment, and ASARCO exited Chapter 11 with a plan that was a full payment plan and a fully funded asbestos trust. This was a company, when it went into bankruptcy, had very few realistic prospects for exiting as an operating business. The fraudulent transfer judgment that Baker Botts obtained radically changed the company's fortunes. As the bankruptcy court itself observed, the case was probably the most successful Chapter 11 of any magnitude in the history of the code, if that gives you some perspective. Next slide, please. So the bankruptcy court awarded a large additional compensation amount to both Baker Botts and Jordan Hayden, and also awarded attorney's fees for the firms in defense of their fee apps. Now, understanding it's important to understand how the fee app war came into being. So the fraudulent transfer recovery, the judgment, was issued against the parent of ASARCO. But as it turns out, the parent became the controlling entity of the company post-confirmation. So there were hard feelings and I suppose some level of I guess, held by the people who controlled the reorganized debtor, who then challenged the fees of the attorneys who had obtained the large judgment against them on behalf of their client, the then debtor. So the facts were somewhat rare. That's not going to ordinarily be seen. In addition, the defense fees for the FIAP, I'm just going to call them defense fees. The defense fees were significant. It was $5 million, I believe, in defense fees. So the reorganized ASARCO appealed to the U.S. District Court, then on to the Fifth Circuit. The enhancement was affirmed, but the Fifth Circuit ultimately reversed on the defense fees, and the Supreme Court granted cert on the issue. As I mentioned, it had been a circuit split, so I guess it was looking. It was the sort of case that the Supreme Court was particularly interested in addressing. Next slide, please. June 5th, 2015, the Supreme Court affirmed. The majority opinion was written by Justice Thomas. Justice Breyer wrote for the dissent. It was Justice Breyer, Justice Kagan, and I believe Justice Sotomayor who joined in the dissent. The Supreme Court ruled that attorney's fees for defending fee objections, we'll call them again defense fees, are per se prohibited, because Section 330 does not expressly, that is statutorily, alter the American rule against fee shifting. Advance to the next slide, please. So reviewing first-year law school, the American rule on fees provides that parties responsible for paying its own attorney's fees and costs unless statute or contract provides otherwise. That's in contrast to the English rule, which provides that loser pays. Next slide, please. So I'm going to read you an important portion of SCOTUS reasoning because SCOTUS certainly speaks better for SCOTUS than I do. The court reasoned thus. Section 330A1 allows reasonable compensation only for actual necessary services rendered, the language that I had pointed out at the beginning of the presentation. That qualification is significant. The word services ordinarily refers to labor performed by for another. Thus, in a case addressing 330A's predecessor, this court concluded that the phrase reasonable compensation for services rendered necessarily implies loyal and disinterested service in the interest of a client. Time spent litigating a fee application against the administrator of a bankruptcy estate cannot be fairly described as labor performed for, let alone disinterested services to, that very administrator. And what's more is SCOTUS characterized its reading of 330 as straightforward. Next slide, please. Let me add, if you don't mind, very briefly, let me add what the dissent said, just if you're interested. The dissent took the opposite position. The dissent reasoned that, in fact, the American rule doesn't apply by its own terms. The American rule has a carve-out for statutory and contract exceptions, and the dissent position was the bankruptcy code includes enough broad language that allows for consideration of relevant circumstances to allow for the ordering of defense fees to be paid, and they disagreed with the stricter interpretation, I suppose, of the statute that the majority of the court took. At this point, I would like to pass it off to Shanti, who's going to cover the next section.
Hi, we could probably advance the slide to the next, and one more slide. So one of the most cited cases across the country since ASARCO, as you all might know, first came out in 2016, and it's the In Re Boomerang Tube Inc. case. It was decided by Judge Walrath out of the District of Delaware. So as we now know, the Supreme Court in ASARCO held that professionals employed under Section 327A may not, under Section 330A, recover fees incurred in defending bankruptcy fee applications. In January of 2016, Judge Walrath entered her Boomerang opinion, finding that neither Section 328A nor the retention engagement agreement can overcome ASARCO's ruling. So as a reminder, Section 328A provides that the trustee or committee may, with court approval, employ or authorize the employment of a professional under Section 327 on any reasonable terms and conditions of employment, including on a retainer, on an hourly basis, on a fixed or percentage fee basis, or on a contingent fee basis. So using that statutory provision, the official committee of unsecured creditors of Boomerang Tube Inc. filed a retention application seeking to employ Brown Rudnick as its counsel, and they included in the application that, and I quote, as part of the compensation payable to Brown Rudnick, the committee agrees that Brown Rudnick shall be indemnified and be entitled to payment from the debtor's estate subject to approval by the court pursuant to 11 U.S.C. sections 330 and 331 for any fees, costs, or expenses arising out of the successful defense of any fee application by Brown Rudnick in these bankruptcy cases in response to any objection to its fees or expenses in these Chapter 11 cases. And included in their application was a proposed form of order that they filed, which included the language that, and this is from the proposed form of order directly, quote, Brown Rudnick shall be indemnified and be entitled to payment from the debtor's estate for any fees and costs arising out of the successful defense of any fee application by Brown Rudnick in response to any objection to its fees or expenses in these cases pursuant to Section 328A of the Bankruptcy Code. So the moment this application filed, you can imagine in light of ASARCO, the parties were going to jump all over it. Andy Vera, the acting U.S. trustee for the region in Delaware, was one of the first ones to object. And essentially, in this matter, the U.S. trustee argued three basic concepts. One, ASARCO barred the provisions. Two, the Bankruptcy Code Section 328A didn't create an exception to the American rule that Abigail spoke about earlier. And three, the provisions are unreasonable and seek to compensate professionals for work well outside the scope of their employment. So let's break down this objection a little more clearly. First, the U.S. trustee argued that Section 328A, like 330A, does not create an exception to the American rule, which is essentially that any party must pay its own fees for work and end the general prohibition against fee shifting, and that's win or lose. The trustee argued that the text of 328 does not specifically or explicitly allow a prevailing party to recover its fees from the other party in an adversarial action. Second, the U.S. trustee argued that even if the American rule against fee shifting didn't preclude the approval of Brown Rudnick's proposed indemnification, those provisions can't be approved under Section 328A anyway, because they seek to pay professionals for work that aren't within the scope of their employment at all. And nothing in the text of 328 provides courts with authority to pay professionals from the estate for work which is considered outside of the scope of the professional's employment. And that's under either Section 327 or 1103. So while Section 1103 permits a committee to retain a professional to provide services, as we now know, ASARCO holds that fees incurred in defending fees are not considered to be for a service. Third, the U.S. trustee argued that the proposed fee defense provisions can't be approved under Section 328A because they're simply not reasonable. The U.S. trustee noted that the provisions fail the reasonable terms and conditions test under 328A. Why? Because if the committee wants compensation for something that isn't considered to be a service to begin with, then it's unrelated to what a professional can be compensated for, and therefore it can't be considered reasonable under 328A. Fourth, the U.S. trustee argued that ASARCO directly bars the fee defense provisions because all compensation needs to be approved for final payment under Section 330, meaning that regardless of what 328 says, Section 330A is still the only provision that truly has the capacity to authorize the award of compensation. And we know ASARCO expressly prohibits compensation for fee defense work under Section 330A. Fifth and finally, the U.S. trustee argued that parties can't consent to unauthorized compensation. The U.S. trustee's ultimate position being that the Code's numerous limitations on professional compensation, including the limitation on defense fees under ASARCO, would be completely undermined if these types of limitations could simply be bypassed through consent. To allow something like this in this scenario could mean that any party could attempt to evade statutory provisions in other parts of the Code simply through consent. So Judge Walrath out of Delaware gleaned three principal arguments from the trustee's five-point objection, and I'll go into that now. So first, the trustee argued basically, right, that ASARCO's holding was broad enough to ban these fee-shifting provisions that Brown-Rudnick was seeking in Boomerang. The committee responded that ASARCO is actually a lot more limited, and it only applies to Section 330A, while it needs to be clear that the committee was seeking retention under Section 328A. Judge Walrath concluded that while Section 328 contained exceptions to Section 330, as previously noted, like the fixed and contingent fees, the instant provisions that they were trying to seek in the Boomerang case were nonetheless impermissible under ASARCO. Applying the American Rules two-part test, Judge Walrath did not find Section 328 to be a specific and explicit statute which authorizes the award of a reasonable attorney's fee or litigation cost that refers to a prevailing party in the context of an adversarial action. Instead, Section 328 merely provides that with court approval, a professional may be employed on any reasonable terms and conditions of employment, including on a retainer, on an hourly basis, on a fixed or percentage fee basis, or on a contingent fee basis. And because the statute does not explicitly refer to prevailing parties, Judge Walrath concluded that Section 328 simply doesn't provide a statutory exception to the American rule and can't provide authority for approval for fee defense provisions. On that point, Judge Walrath actually went a little bit further and noted that in at least 6 places in the Bankruptcy Code, Congress used the express language necessary to create an exception to the American rule. So it's particularly telling, from Judge Walrath's perspective, as well as the U.S. trustee, that there is no American rule exception language found under 328 in the Bankruptcy Code. Next, the court evaluated the contract exception to the American rule. The committee argued that the ASARCO decision recognized that parties could contract out of the American rule, and the holding of ASARCO only found that Section 330 did not have an explicit exception to the American rule. And recall that the U.S. trustee had responded that if parties could override ASARCO by contract, there's nothing stopping other parties from overriding other Bankruptcy Code provisions relating to compensation. So again, Judge Walrath sided with the U.S. trustee in determining that the parties cannot by contract violate another provision of the Code. So therefore, although the committee is correct that the ASARCO court did acknowledge a contractual exception to the American rule, any such contract still has to be consistent with other provisions of the Bankruptcy Code in order to be withheld. The court then analyzed the underlying retention agreements themselves. The court found that the retention agreements were contracts and also needed to make the next determination of whether the contractual exception to the American rule was available for these retention agreements. The U.S. trustee had argued that they are not exceptions to the American rule because they're not agreements between two parties that in the event of litigation between them, the loser would pay the winner's costs. In this case, the U.S. trustee noted that the agreement was actually just a one-way street, where committee counsel would seek a ruling that the estate was liable for their legal fees, but yet there was no similar symbiotic commitment to the estate. The U.S. trustee argued that the committee can't, by contract, require a third party, in this case the estate, to pay their legal fees in the event of litigation by someone else. And again, surprisingly, but not really, the court sided with the U.S. trustee and said that there was no contractual exception to the American rule available because it was noted it was not a contract between two parties, providing that each will be responsible for the other's legal fees if one loses the dispute between them. Rather, what we have here is a contract between two parties, the committee and committee counsel, and that in the event committee counsel wins a challenge to its fees, a third party, the estate, would have to pay their defense costs even if the state was not the party who objected to the committee counsel's fees. The court agreed with the U.S. trustee that this is simply not the typical contract which would modify the American rule. Rather, the agreements at issue sought to impermissibly bind a third party, and that wasn't going to fly. Most importantly, the court found clear that retention agreements in bankruptcy aren't simply contractual matters. It's the obligation of the bankruptcy court to approve the terms of employment of professionals in accordance with the provisions of the bankruptcy code, regardless of what terms are articulated in the actual employment contract. So if the court finds that a contract that the debtor and the committee expressly negotiated, if the court finds that to be impermissible, the court has within its discretion to approve or even modify that agreement. The court also looked at the scope of the retention under Section 328. The U.S. trustee contended that defending fee applications do not relate to services rendered by the professionals. So, stated another way, if committee's counsel were defending their fee applications, they were only performing services for themselves, not for the estate, not for the debtor, not for the debtor's constituencies. So relying on that language and the definition of services from ASARCO, the court agreed again. And finally, the court concluded that the outcome is no different if the court were to view the money spent as part of the fee defense process as an expense as opposed to a fee. But ultimately, in Boomerang, the court approved the applications without the fee defense provisions included in them. And since 2016, in the Walrath decision in Boomerang 2, there have been a couple other cases that have come out of other jurisdictions in the country addressing many of these ASARCO principles. And Kyle Hirsch will discuss them.
Thanks for that nice pass, Shanti. So one of the cases that I'm going to discuss is a Nortel Networks case. For those of you that aren't familiar with the Nortel Networks bankruptcy cases, they're really fascinating in one of these models of behemoth insolvencies cross borders. Just by way of context, on the same day as the Nortel Networks cases were filed in the U.S., there were two other proceedings initiated. One of them in Canada, which was initiated involving other Nortel affiliates and its ultimate parent. There were also several European, Middle Eastern, and African-located affiliates that were placed into administration under the control of court-appointed administrators and foreign representatives in Wales, England. So this is one of those many, many different pieces and things going from the overall bankruptcy case. Case was filed in 2009. One of the U.S. debtors is an entity called Nortel Networks Capital Corporation. That is a special purpose financing vehicle that issued senior notes pursuant to an indenture. And in the U.S. bankruptcy proceeding, the indenture trustee was part of the unsecured creditors committee. Two of the note holders that represented 90% of the notes controlled by that indenture instrument were sophisticated investment funds. And when the indenture trustee sought recovery of about $8.1 million in fees, these two note holders objected to a little over half of those fees. So among the players involved was the Dewey law firm that sought nearly $3 million in fees for its work representing the indenture trustee for a portion of time. These note holders objected to $1.9 million of those fees. The Patterson-Belknap law firm replaced Dewey mid-course, and they submitted an application for a little over $4 million in fees, and these note holders objected to $2 million. A third firm, which represented the indentured trustee in the Canadian proceedings, the Borden-Ladner firm, sought a mere $550,000 in fees, and the note holders objected to about $190,000. There was also a portion that the indentured trustee was seeking recovery of, nearly $400,000. Ultimately, and a good portion of this case, which was decided in March of 2017, discussed the process for evaluating the actual fees incurred and whether the indentured trustee was following appropriate business standards. Really, the note holders' objections were largely overruled. Of the $1.9 million of objectionable fees for Dewey, only $640,000 of the objections were sustained. For the Patterson-Belknap firm, $270,000 out of the $2 million of objectionable fees were sustained. And the Borden-Ladner firm prevailed on its entirety of its fees, and the note holder's objection was entirely overruled. What was really interesting about this case and is that the court pulled in the ASARCO logic, and this was Judge Kevin Gross, who sits on the same bench as Judge Walrath in Delaware. And the discussion came up about whether the existing law firm for the indentured trustee, the Patterson-Belknap firm, could then pursue an award of fees in this non-Section 328 or Section 330 context. Judge Gross talked about ASARCO and how the American rule provides for this contractual exception. And he talked about the Boomerang Tube case and how the court, Judge Walrath in that case, did not find that the contract exception applied. And Judge Gross really focused on, in the Boomerang Tube case, that the fee agreement was not with the debtor or the estate, but it was a third party and not a bilateral agreement that was intended to bind the estate. Looking at the indenture agreement under which the indenture trustee and its professionals were seeking recovery of its fees, Judge Gross focused on a couple of the different provisions. One of them that addressed that the issuers, who was one of the debtors, shall pay to the trustee compensation for its services as agreed separately by the issuers and the trustee. So that addressed the issue about the estate or a debtor being part of the agreement. But the real key was the language in the indenture agreement where the issuers, again, one of whom was a debtor, severally and not jointly, shall indemnify the trustee or any predecessor trustee for any loss, damage, claims, etc., including the costs and expenses of defending itself against any claim or liability in connection with the exercise or performance of any of its powers or duties hereunder. Judge Gross really focused on that language and said this is an indemnification provision agreed to by the debtor for defending the fees that were at issue in this fee objection. So this Section 606B of the indenture agreement required the debtors to indemnify the indenture trustee for, quote, costs and expenses of defending itself. Judge Gross looked at this and said, look, this is clearly outside the circumstances of ASARCO and Boomerang. In fact, that's the quote out of the case. The indenture is clearly outside the circumstances of ASARCO and Boomerang. There's not a real discussion or analysis as to why it's outside, but I think the implication is, number one, not only is this indenture trustee, this indenture agreement being presented for payment outside the scope of Sections 328 and 330, but there's also clearly a debtor entity who had agreed to these provisions, which is an express contracting around the American rule, so it doesn't implicate ASARCO, and the Boomerang Tube decision didn't apply. So Judge Gross concluded that the indenture trustee and its lawyers could apply for fees in this dispute. Later on in the year, in September of 2017, another case came out in the District of New Mexico. It's a case called In Re Hungry Horse, LLC. The bankruptcy judge is David Thuma. He offered somewhat of an advisory opinion to guide the form of what he believed are enforceable language for recovering fees on fees. So in this case, again decided out of the bankruptcy court in the District of New Mexico in September of 2017, the debtor was engaged in oil field services in southeastern New Mexico. When the debtor filed the case, the original law firm that had applied for approval was the Ken Wagner law firm as bankruptcy counsel. About a year later, one of the lawyers at the Ken Wagner law firm switched firms. That was a gentleman named Louis Puccini Jr. When he left the firm, and we can all probably take some implication from what happened next, his rate shot up by $75 an hour. So he applied on behalf of the new firm, the Robert D. Gorman PA firm, as replacement bankruptcy counsel for the Wagner law firm. The Unsecured Creditors Committee took issue with two aspects of the application for approval of the Gorman law firm, which was submitted for approval under Section 328. The two objections were first about Mr. Puccini's firm rate. It increased by $75. The Unsecured Creditors Committee said that wasn't justified for a handful of reasons. And the other issue was the challenge to the retention agreement that attempted to contract around ASARCO. So the language I provided expressly in these materials, so people can see what the parties tried to do. The client agrees that all reasonable fees and expenses incurred by the Gorman firm in collecting and or obtaining approval of its fees and costs by bankruptcy or any other court shall be added to the total fees and costs due from the client. All such fees and costs, if disputed, shall be resolved by the court. So on its face, it appears as if the Gorman law firm took note of ASARCO and made it very clear in the retention agreement that was now being submitted for approval by the bankruptcy court that this was explicitly intended to contract around the ASARCO issue and the American rule. So the court resolved the issue about the amount of Mr. Puccini's fees and did so on an interim basis, and then went into a pretty thorough discussion about ASARCO and the other cases that we talked about, both Boomerang and Nortel Networks. With respect to ASARCO, the court really focused on the Supreme Court's affirmance of the Fifth Circuit's reversal of the fee-on-fee award by referencing the American rule that each litigant pays his own attorney's fees, win or lose, unless a statute or contract provides otherwise. When the court talked about the Boomerang Tube decision, they went into a lot of detail about how the fee defense provision was deemed to not fall within the contract exception to the American rule for the reasons described by Shanti when she discussed the Boomerang case. What was interesting is that this judge really took note of the discussion that Judge Walrath concluded that a fee-on-fee provision could never be approved under Section 328 because those could never be deemed reasonable terms, which is what's required under 328. But Judge Thuma also added that a part of the Boomerang decision focused on market factors. And the quote out of the Boomerang case that Judge Thuma focused on is that the cases that considered market factors relevant to the question of whether defense fees can be recovered all predated the ASARCO decision, which expressly rejected the consideration of such factors. Moving on to the Nortel Networks case, which Judge Thuma gave very short shrift, he really limited that case because it wasn't a 328 case and because the counsel for the indentured trustee wasn't employed by the bankruptcy estate, even though the debtor had agreed to those fees. So in deciding deciding whether or not this particular fee provision was appropriate under Section 328, Judge Thuma talked about how employment terms and conditions approved under Section 328 really dictates and overstates the general reasonable compensation for services rendered language in Section 330. So the previously approved Section 328 terms and conditions control the professioner's compensation, not the Section 330 requirement of reasonable compensation. So in looking at this particular case, the judge looked at sections at ASARCO and said that's really a Section 330 case. We're dealing with a Section 328 case on the approval of a retention agreement, and concluded that ASARCO does not implicate approval of retention agreements under Section 328. In evaluating this, it said, look, I don't think the Boomerang Court really applies here, because the Boomerang decision came to this ultimate conclusion that a Section 328 retention agreement can never include a fee-on-fee language because that can never be a reasonable term. Getting into some of the specifics about what happens with lawyer engagement letters, Judge Thuma focused on a number of elements of a retention agreement that are reasonable terms that don't necessarily implicate the estate. The client can agree to a specific court's jurisdiction. The retainer agreement can include initial retainers and replenishing retainers, which really go to benefit the lawyer and not the estate. There can be prompt provisions for payment of bills, which again go to benefit the lawyer and not the estate. And it's these additional terms that can be included within a Section 328 approved retention agreement that don't always go to benefit the estate. They're not always services benefiting the estate, but it's the overall engagement and retention of bankruptcy counsel and the terms of that engagement that Judge Thuma stepped back and said, look, we need to see what is reasonable for the purpose of representing the debtor. Interestingly, he focuses specifically on New Mexico. He says in jurisdictions such as New Mexico, which typically have smaller bankruptcy cases with smaller fees, fee defense can be a sizable percentage of the total fees billed. So if a state counsel were forced to successfully defend its fees on its own dime, the net compensation in a bankruptcy case could be substantially reduced. So in conclusion, what Judge Thuma decided was that there is an exception to the American rule, and you can have fee-on-fee provisions that can be reasonable terms under Section 328, and then provided some guidance and said, look, and any time you have a fee provision, it really should provide that it's agreed to by the bankruptcy estate, which then addresses the issue that arose in Boomerang, that it was a third party that was agreeing to bind the estate. It should allow the bankruptcy court to review and approve the reasonableness of any fee defense fees sought. The estate should agree to a very similar provision for committee counsel, thus providing more of a level playing field. And no fees should be allowed for unsuccessful fee defense work. And then he offered an example provision for an enforceable fee defense clause, that the client agrees to pay all reasonable legal fees and expenses incurred by the firm and also by any counsel retained by the unsecured creditors committee if one is formed in the client's bankruptcy case for successfully defending their respective fee applications. The bankruptcy court must approve all of such fees as reasonable. The client will have no obligation to pay for any fees or the expenses the firm incurs defending fees that are not allowed. So taking the Nortel case and the Hungry Horse case in stride, I think the Nortel case could be used to enhance the Boomerang limitation that applies to the analysis of contracts involving the debtor and the debtor's estate. What I think creates a little bit of an imbalance if that position is advanced is that certain estate representatives, like committee counsel, normally don't include a retention agreement with a representative of the estate. It's a retention between counsel and the committee. On the flip side, the debtor is almost always in a position where they can provide for protection for debtor's counsel in this kind of a fee-on-fee debate. And if you take the Hungry Horse guidance into account, maybe that fee agreement needs to have a duplicative provision for estate professionals that are not controlled by the debtor, but that's not necessarily where Nortel falls out. I think one of the shortcomings of the Hungry Horse case is that it's real easy to take that one in a vacuum and view it as only applicable to perhaps smaller bankruptcy markets where judges are a little more predisposed to protect the legal professionals within that market. So I do think Judge Thuma's position, which offers a model agreement, should be considered carefully outside the District of New Mexico as to how well it'll apply in more robust bankruptcy markets. Shanti's now going to address another case that came up, which addressed fees a little more generally.
Thanks, Kyle. So in the ASARCO case, one of the parties raised concerns to the Supreme Court about how professionals might be targeted with frivolous objections to fee applications in a post-ASARCO world where the courts are rule in one direction. And the Supreme Court actually addressed that concern in its footnote 4 of the ASARCO opinion. And it notes, to the extent, I'm going to paraphrase, to the extent a party harbors any concern about the possibility of frivolous objections to fee applications, we note that the Federal Rule of Bankruptcy Procedure 9011, the Bankruptcy Code's analogous Civil Rule 11, authorizes the court to impose sanctions for bad faith litigation conduct, which may include an order directing payment of some or all of the reasonable attorney's fees and other expenses incurred as a direct result of the violation. So considering that footnote, some professionals in the country took the Supreme Court's footnote to heart, and in re KSL Media, which is a bankruptcy case out of the Central District of California, the professionals ended up encountering a situation very similar to this. In that case, the debtors filed Chapter 11 petitions using the law firm of Landau, Gottfried & Berger, LLP, as their counsel. And a few months later, the Office of the United States Trustee requested the appointment of a Chapter 11 trustee. And a few days after that, a motion was filed by Landau on the debtor's behalf, seeking to convert the case to a Chapter 7. The Chapter 7 trustee filed applications to employ Pacholsky, Stang, Zeal, and Jones as counsel. And Chapter 11, you recall Chapter 11 debtors counsel Landau, during this process attempted to prevent Pacholsky from being retained as counsel, claiming that there were certain conflicts in place. And wanted to ensure that there also was a financial advisor that was selected by the Chapter 7 trustee that also they believed should not be retained. Landau filed an objection to Pacholsky's retention application, but then actually withdrew it, and Pacholsky was eventually retained as counsel to the Chapter 7 trustee. Kelly Dry was retained as special counsel to investigate the bankruptcy professional's actions in the case to figure out exactly how the landscape of the case had changed so much since the initial Chapter 11 filing. And eventually, what Kelly Dry's analysis showed is that all professional fees that were involved in the Chapter 11 leading up to the Chapter 7 needed to be reduced. So Pacholsky, the trustee, and the Chapter 7 trustee's financial advisor each reached a settlement on their fees. But Landau, the original Chapter 11 debtor counsel, refused. So when Pacholsky, Kelly Dry, and the financial advisor submitted their fee applications, Landau objected, realleging that there were certain conflicts in place that should prevent them from being allowed to be paid. Landau also requested that the bankruptcy court vacate the retention orders of each of the professionals. And obviously the professionals, as a professional courtesy, gave Landau the opportunity to withdraw the objection, but it chose not to. In the end, Pacholsky, Kelly Dry, and the financial advisor filed a motion for sanctions pursuant to 9011. They sought $244,000 in fees and expenses, which is what they incurred in pursuing the sanctions motion. And specifically, at the end of the day, the court found that Landau had violated Rule 9011 by filing the objections for an improper purpose including to cause unnecessary delay and to thwart the trustee's investigation into Landau's own conduct. And additionally, Landau's objections failed to articulate any legal or factual basis for its objection. Ultimately, the court granted $207,000 in change in fees under Rule 9011C1A, and then $100,000 in sanctions under Rule 9011C2. So I think all parties, and it's clear to understand from this that the court sought to deter future conduct of this kind. You want to be very careful when you're filing fee objections to professionals, because obviously it's not so simple as to say this falls outside of the scope of 328 or 330, or that there's no basis for, to say that you can contract around the American rule. Notwithstanding all of that, any objection to fees needs to be based on the actual services that were provided, as opposed to running about and creating unnecessary problems for the court and basically taking up judicial time to deal with stuff, because you will get caught. And I think we were going to talk a little bit about just some additional thoughts and commentary that has come out since ASARCO, and any other tips and points that we can offer. Abigail, did you want to?
Absolutely. Can you hear me?
Yes.
Yeah.
Okay, here we go. The first thing that I wanted to point out was that Cliff White, who is the United States trustee, the guy in Washington, that guy, in March of 2016, after ASARCO came out, he was speaking at an ABI meeting in California, and he made some written comments in which, amongst other things, he acknowledged that ASARCO demanded a much stricter position than what the United States trustee had actually advocated for at the Supreme Court. And his office issued comments in the form of question and answer, which are now available on the UST's website, which I would recommend that you all take a look at if you get a chance, because as a practical matter, if you're going to draw an objection to FIAP, at the end of the day, a real objection is probably going to come from the United States Trustee's Office, unless you have sort of exceptional circumstances like what you had in ASARCO. I would argue that most fee applications can probably be resolved vis-a-vis negotiation between the private parties. But if you're facing a problem with the UST, it's a bit of a different animal. You should probably go through and be aware of what positions the United States Trustee's Office may be taking, because they list them. For example, the United States Trustee will object to any defense fees incurred after an objection has been filed. Generally, they're not going to object to fees related to preparing the FIAP or negotiating the FIAP. But apparently, if the objection gets filed, they will object to any fees incurred after the objection is filed. What seems to be a bit of an open question, perhaps, is if an objection is filed, and then you continue incurring fees in good faith negotiations to resolve the objection, what is the United States Trustee's Office position going to be in that situation? In addition, the United States Trustee's Office will object to any attempt to use Section 328 to approve a payment of defense costs. They are taking the position that the reasoning in ASARCO applies equally to a 328 as to 330. In addition, just sort of as an intellectually interesting matter, on February 12, 2016, about the same time that Mr. White made his comments, there was an op-ed piece that was run in the New York Times by Professor Stephen Lubin of Seton Hall Law. You all might be familiar with him. He's a relatively frequent contributor to the New York Times. He wrote an article about ASARCO and it's sort of projecting into the future and what it might mean. And number one, he suggested this may mean that over time, people are going to turn to the Southern District of New York even more in the face of boomerang, as versus filing in Delaware, because it might be perceived as additionally friendly to fees. And he also expressed some concerns that in reality, what may happen is that attorneys are going to compensate for the cost that they may lose in defending FIAPs by building it into their rates and raising rates, or alternatively hiding fees. respectfully to Professor Lubin, I'm not sure that I agree with his analysis that that attorneys will hide fees. I've done this a long time, and most attorneys that I know would never commit a fraud upon the court by hiding fees and mischaracterizing them. But Professor Lubin thought that was something that should at least be acknowledged. So what's a possible solution for all of this? Well, the obvious solution is amend the code, change the code to allow for fee on fees to be compensated in a circumstance where it's successful. Obviously, if you have fee on fees, and it's not successful, perhaps it shouldn't be compensated. But we could possibly amend the code. And several commentators, law review authors, that sort of thing, have made suggestions regarding what kind of language might be considered to resolve the matter statutorily. I believe, unless Shanti or Kyle would like to add anything, perhaps I was otherwise going to pass it back to the moderator. Shanti or Kyle, do you have anything to add to this?
No, I'm good. Thank you, Abigail and Kyle.
I also have nothing further to add.
Well, this is Amy back at the ABI.
Well, I think at this point we're going to pass it back to the moderator, and that is the end of the presentation. Thank you all so much for listening in, and we hope that we were able to bring some ASARCO illumination to you all.
Thanks so much, Abigail, and thanks to you all, Kyle, Shanti, and Abigail, for sharing your time and insights with us today on this very important topic. Thanks also to the ABI Young and New Members Committee for hosting the webinar. If you're not a member of that committee but are interested in joining, membership is free to you as an ABI member, and you can sign up for this or any other committee at committees.abi.org. For those of you needing CLE credit for this program, our CLE coordinator will send an email to you in about a week or so with directions on how to obtain your CLE credit. Thanks again for attending our ABI Live webinar. Our next free webinar will be this Thursday at noon Eastern on key provisions in Section 363 sale orders. For more info or to register, please visit abi.org. Thanks so much and have a great day.